Thank you. Thank you very much.
Well, now let's take a look at the interactive process. The interactive process is a major piece of the ADA and a reasonable accommodation. Employers have an affirmative duty to sit down and talk about it, which makes a lot of sense. I mean, there's some common sense in this area of the law. I mean, you've got such an individualized inquiry under the ADA. What is the person's condition? What are the limitations? What are the essential and non-essential functions of the job? If I change one little fact in there, you could get a whole entirely different outcome. So sitting down and talking about this is not only mandatory, it's a very good idea. Now, as we go through this list that I've put together here from the regulations as to what we should be doing in our interactive process, one thing should be foremost in your mind: documenting what is happening. I mean, document what is being suggested, all the facts that are out there. And when I say document, a lot of folks think, well, I'm going to sit down and take notes. That's great. But notes don't necessarily capture everything. We are living in a digital world. You want to be able to prove later, if it becomes an issue, you want to be able to prove later that you engaged in this process in good faith, that you did look at these types of things, or where there were disagreements or something like this. You live in a digital age, so I suggest you use our technology. I suggest recording the entire conversation. And I would tell the employee, look, this is an important process. We want to make sure we get it accurate, so I'm going to record this. Hint, hint, hint. In a lot of states, one-party states, I should specify, where only one party has to know that you're doing the recording, the employees a lot of times are recording you. So let me tell you, a word to the wise, this is a great way to document it. And if you need it later to prove that you did go through this process and what all was discussed, there's nothing better than a digital recording. That's something you should seriously consider. So let's look at this list, this checklist of items that I've put together for you here that you want to take a look at. All right, first and foremost, as you start the interactive process, identify the essential functions of the job. Include a review of the job descriptions, which, hint, 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 your job description should be updated. Remember, that is a major issue with the EEOC these days. Any memorandums or anything that describes the duties and responsibilities of this job. Essential and non-essential functions. Remember, essential functions you are not expected to give away. Non-essential functions you are. So make sure that you've got a note on both of them. Obtain from the employee's health provider a listing of the employee's work limitations. Identify each restriction or limitation that might affect the employee's ability to perform the essential functions of the job. So obviously, before you even sit down and go through this interactive process, you're going to have the employee's medical certification form completed by the healthcare provider, as well as a listing of limitations. How long can they sit? How far can they walk? How much can they lift? How long can they stare, like at a computer? Things like that. Meet with the employee. You got to review and confirm these limitations. Is this accurate? And make sure you review the essential functions. Assess and discuss with the employee these limitations. And throw out and brainstorm some reasonable accommodations, if any, that would allow this person to do the essential functions of the job. All of this should be documented. And again, I suggest recording the entire conversation. Now, if the employee doesn't agree with the limitations, that employee. It's the employee's burden to get a clarification from the physician, because you've got something in your hand here saying that this is the limitation. If you don't agree with these limitations, get a second opinion and follow the ADA. But yes, you can send that employee to a physician of your choosing. Review each accommodation that's been tossed out there. Is it feasible? Would it be effective? Again, you're documenting everything here. Oh, hint, hint, hint. If it isn't written down, it didn't happen. Both parties should be involved in this exchange. You're problem solving. If an accommodation isn't feasible, because maybe it's an undue hardship on you, maybe you don't want it as the employer, and it's not feasible, you need to document why it won't work. If the employee suggests something and it won't work, document it. If you suggest something as the employer and the employee says it's not feasible, ask them why. Document the reasons that something will work or won't work. Consider the employee's preference. I'll tell you, this is really critical, because if the employee agrees and you agree, the chances there'll be litigation or other types of issues later are greatly diminished. Select an accommodation that might work and implement it. Conclude this process by documenting what the plan is. What did you agree on? Or what's going to happen next? Maybe the documentation is another physical. Confirm with the employee in writing that this is adequate and this does meet what he or she needs. That is basically the process that is outlined for you in the regulations. I suggest you follow it. I suggest you follow it. Print this process off. Check by check by check. Make sure that you are going through this. It's a great way to document, and it's a great way to show that you followed what is required by the regulations. Monitor the plan going forward. Are these accommodations working? Are the adjustments still necessary? You understand, this is an interactive process. The employee's condition could get worse. An accommodation that worked this year might not work next year. So this is a constant duty. It's ongoing. Remember, the ADA doesn't have a time frame to it. The FMLA does. You got 12 weeks. You're done. Not with the ADA. It goes on forever. So yes, you might be going through this interactive process with the employee every year. The EEOC has gotten in on the game here. You kind of thought they would. They've issued a final rule on the ADA and its opinion on the interactive process. And it basically says there are two distinct steps. First, the individual must request the reasonable accommodation. Okay, well, unless it's absolutely obvious, the employee has to let you know. And remember, we talked about this already. They have to use plain English. They don't have to come up and say, I need an accommodation under the ADA, and let's engage in the interactive process, shall we? Doesn't work like that. I'm depressed. I have kidney stones. Something like this, okay? Second, the employer must engage in the interactive process. This is not optional. It is not optional. Mandatory. Now, it's not just that it's mandatory to go through this interactive process. It's a very good idea. First of all, these people have been dealing with this disability probably their whole life. So they might very well have a very economic and very simple way of dealing with this. It might not be as bad as you think. But I'll tell you, secondly, asking people with disabilities how to accommodate them does a lot to help avoid punitive damages later if you end up in court. Punitive damages are meant to punish. It's meant to hurt, inflict pain on you. That's why we use the term punitive. It means the court's mad at you. You can show a lot of good faith by documenting and engaging in the interactive process, and I suggest that you do. Now, just to show you how important the interactive process is, we got the Davis versus Guardian Life Insurance Company. Well, basically, here's what happened. Miss Davis worked for Guardian Life Insurance Company as an underwriter. She then contracted Crohn's disease, which, as a result, she started missing a great deal of work. Well, she worked it out with her supervisor, and she began working some different types of hours. She was actually allowed to work at home 3 days a week, and in the office 2 days a week. Well, this worked for a while. The company got her all set up with the equipment she needed. She could work from home, fax machine, computer, telephone, all that kind of stuff. And Davis was allowed to switch the days she was in the office, depending on her condition and maybe some medical appointments. Well, later on, her condition got worse. And as a result, Davis asked if she could work exclusively from home. And Guardian is basically like, well, we're not so sure about that because we do need to have some interaction. So we're thinking we need to stick with this 2 days a week you're in the office. So they sent her a letter denying her request, saying, you know, we need to work out what 2 days a week you can be here or whatever details there are. Davis never responded. She didn't even attempt to return their calls. So she never came back to work. So she was terminated. Instead of talking to Guardian, she filed a lawsuit. Well, the jury heard all of this, and they awarded $1.5 million to Miss Davis. Now, that's like hitting the lottery. You just won $1.5 million. I'll tell you, Crohn's disease or not, I'm going to Disney World. Well, there is something in the court, something in the law, that if a judge really disagrees with the decision, that judge can impose something called a directed verdict. What's that mean? It basically turns to the jury and says, look, you're too stupid to make a decision here. So the judge takes the award of $1.5 million and takes it back from Miss Davis. The judge basically says, look, Miss Davis, you didn't engage in the interactive process. That's required. Both the employer and the employee equally bear the responsibility of engaging in this process. And they try to get you to come in, you wouldn't respond, so they're like one hand clapping here. So guess what? Because you did not engage in the interactive process, you lose. I don't care what the jury said. You lose. Now think about this. Miss Davis just lost $1.5 million, and all she would have had to have done was get on the bus or something and get in there and talk about this to Guardian Life. She wouldn't have had to have come to an agreement, but you gotta talk about it. That's how critical the interactive process is to the ADA. Now, it's important to understand, under the ADA, once you have granted someone a reasonable accommodation, that duty doesn't stop. Employers have a continuing duty to accommodate. Well, what's that mean? Conditions change. An accommodation that worked now might not work in a year. So you are always reevaluating this. And yes, you might need to sit down with that employee again and go through the interactive process. We got a great case a few years ago, Humphrey versus Memorial Hospitals. And here's basically what happened. Carolyn Humphrey was a medical transcriptionist for Memorial Hospitals, and she was diagnosed with obsessive compulsive disorder. Well, this caused all kinds of problems for her, so to accommodate her condition, MHA allowed Humphrey to work on a flexible schedule, and that seemed to work for a while. That seemed to solve the problem. But eventually, somewhere down the road, it didn't solve the problem anymore, and she was continuing to have problems. She would miss work. So she asked her supervisor if she could work from home. Can she telecommute? And she based this request on the fact that other medical transcriptionists were allowed to telecommute. Well, MHA refused, and it claimed that it had already accommodated her condition, so it was done. Also, MHA had a policy in place. It didn't allow employees who had attendance problems to work from home. So MHA reasoned that if your attendance improves, yeah, we might consider letting you telecommute, but your attendance has to get better. Now, isn't this a little ironic? Her condition is causing her to have attendance problems. And if her attendance improves, well, then we'll accommodate you. Just, you see, you can tell right away the employer is going to have a real problem here. Well, when her attendance got worse, surprise, surprise, she was terminated. Humphrey sued the employer under the ADA. The court found for Humphrey. Specifically, the court held that even though the employer had already made one accommodation for her, it was, quote, quote, abundantly clear that the flex schedule was insufficient and wasn't working. And since the employer already demonstrated that allowing medical transcriptionists to work from their homes isn't an undue hardship, it had employees doing that now, such an accommodation should have been made for Mrs. Humphrey. If you'd have made that accommodation, the court says, she would still be working there. So the decision went to Miss Humphrey. Hint, hint, hint. Your duty to accommodate never ends. Conditions change, so it's time to reassess. Now, not surprisingly, the circuit courts have latched on to this interactive process. Circuit courts are supporting the EEOC in this. And I've pulled some language here that I think is pretty convincing from the Sixth Circuit, typical type of circuit. Well, the Sixth Circuit has ruled that the duty to engage in the interactive process is mandatory. You don't have any choice. If you don't do it, you lose. Remember Mrs. Davis. The court also ruled that the interactive process requires communication and, quote, quote, a good faith exploration of possible accommodations. Well, that tells you right there, go through that process. The circuit court has also held that the purpose is to identify the precise limitations resulting from the disability and any potential reasonable accommodations. Now, doesn't that sound exactly like the EEOC's direction? Where employees request a reasonable accommodation from the employer, the ADA mandates that the employer engage in an individualized inquiry into that employee's specific condition and needs. Well, what's that tell you? Every situation is going to be different. Everything is different in the ADA. It's an individualized inquiry. In other words, you cannot determine what the reasonable accommodation is if you don't do that. The Sixth Circuit also ruled specifically that the ADA regulations anticipate that an employee might not be in the position to know what a reasonable accommodation would be. And they require that the employee and the employer engage in this process to find out what accommodations are possible and adequate. So, guess what? There is no doubt whatsoever that the interactive process is mandatory, and I suggest you follow those steps that we have outlined for you in this course. Also, don't forget my 4 employment law videos that can help educate you in the world of employment law. You can do this right at your desk. They all come to you on a flash drive. So you can load them in your computer, load them into your intranet for anyone to learn. These are at my website, scottwarrick.com, under the Employment Law Videos icon. One of them is Understanding the New Americans with Disabilities Act of 1990. Another one is understanding the new Family and Medical Leave Act of 1993. Another one is, oh no, it's Wage and Hour, understanding the Fair Labor Standards Act of 1938. And of course, avoiding Pervertgate, understanding and preventing workplace bullying and harassment. Again, you can go to scottwarrick.com. There are samples from each of these videos there under the employment law video icon. Well, thank you for taking the time to go through this program with me. If you want more information on these types of topics, please feel free to go to my website at scottwarrick.com or shoot me an email at scott@scottwarrick.com.